know it's 101. Does everybody, oh geez. Okay, good afternoon, everybody. We're going to get started in just like 1 minute or so. Folks in the room are just getting settled. So thanks for your patience. Okay, all right. Thanks for your patience for folks online. I am going to call the July 22nd meeting of the Domestic Violence Criminal Justice Response and Enhancement Advisory Council to order. And the first item on the agenda is just welcome and introduction of council members. I will go around the to the folks in the room first, and then to the folks on Zoom. So good afternoon, everybody. My name is Megan Scanlon. I'm the CEO at the Connecticut Coalition Against Domestic Violence and co-chair of the committee. I'll pass it to Senator Flexer.
Good afternoon. My name is May Flexer. I am the other co-chair of the council, and I am a state senator who represents Thompson, Putnam, Killingly, Pomfret, Brooklyn, Canterbury, Scotland, Wyndham, and Mansfield. And should we kick it all the way over to the far right and then go all the way around the circle? So we'll call on Merritt next. Thank you.
Good afternoon, Merritt LaJoy, Complaint Officer for the Office of the Victim Advocate and co-chair of the Court-Based Issues Subcommittee.
Good afternoon, I'm Nancy Turner, board member representing the Connecticut Board of Pardons and Parolles.
Good afternoon, Phyllis DeCara, board member.
Good afternoon, Ryan Maynard, captain with Connecticut State Police.
Good afternoon, all. Alaric Fox, chief of the Enfield Police Department and representative of the Chiefs of Police Association.
Hi, I'm Tammy Nuccio, state representative of the 53rd District, which is Tolland, Willington, and Vernon, and appointee to the committee.
Good afternoon, Karen Foley O'Connor, CEO of the Network Against Domestic Abuse, serving North Central Connecticut, a retired Connecticut State Police Sergeant.
Good afternoon, I'm Jody Tuner. I'm the Director of Family Services, part of Connecticut's Judicial Branch. Good afternoon, Mark Pelka, Judicial Branch Office of Victim Services Director.
Good afternoon, Johanna Canning, designee of the Chief Public Defender.
Sarah Steer, Senior Assistant State's Attorney, London.
Great, thank you. Moving on to folks on Zoom, I'm just going to go by order of who I see in the box. Andrea?
Good afternoon, everyone. Andrea O'Connor. I'm the Family Violence Victim Advocate Program Manager for the Umbrella Center for Domestic Violence Services. I supervise the court-based victim advocacy program at Milford, New Haven, and Derby courts.
Danielle?
Good afternoon, Danielle Cinquedoce. I'm Regional Manager with Family Services in the Judicial Branch.
Captain Party?
Good afternoon, Heather Party. I'm a captain with the Windsor Police Department.
Ginger?
Hi, I'm Ginger Wilk. I'm the Senior Director of Reentry Services for CRJ Family Reentry, and I oversee the programs for DV offenders across the state through CRJ.
Nancy?
Afternoon, Nancy Tyler. I am the survivor representative appointed through CCADV.
Great. Shauna?
Good afternoon, everyone. Shauna Harrington, Director of Legal Advocacy at CCADV.
Michael?
Good afternoon, Michael Tatro, Legal Project Manager at CCADV.
Great. And Valina?
Good afternoon, Valina Carpenter, Office of Policy and Management, Criminal Justice Policy and Planning Division.
Great. Welcome. All right. That wraps up the welcome and introductions of council members. Moving on to item 3, approval of the April 22nd meeting minutes. Do I have a motion to approve?
Madam Chair?
Yeah.
If I could make a clarification?
Sure.
Thank you. I don't want to revisit the issue because I know it became confusing last time, but just as a point of clarification so that the record is appropriate, under subcommittee reports, which is Roman numeral 4, the police response, which is letter A, dropping down to Roman numeral 2 on the second page, is referencing the discussion that I largely led, and it's identifying a whole number of statutes. Just so we're all clear, and I know it is confusing, of that list, there are only 3 that need attention. Of the ones that you see, the balance are fine, but I was trying to draw the group's attention to just stalking second, harassment first, and harassment second. Okay. Now, whether that requires modification or whether those comments for this meeting are sufficient to provide that clarification, I certainly am if the chair is so satisfied. Thank you.
Okay, thank you. Any other clarifications, corrections, comments, Senator?
Thank you. Chief Fox, how would you like this section to read? I just want to make sure you're making an effort to make sure this is completely accurate. So I just want to make sure if we're doing new minutes that it reads exactly as you're suggesting.
Of the list, the cleanest way to do it would be of the list of statutes that are included on this document, the only 3 numbers that need to be there are 53A 181D, which is currently there, 53A 182B, which is currently there, and 53A 183, which is currently there. The other ones can be struck as currently adequate. And I just, perhaps in the note-taking process, everything that I was speaking of was included, and I can understand where that would have happened. But the only ones that would require, I would respectfully offer potential legislative correction are those 3, 181D, 182B, and 183. Thank you.
Okay, thank you. Okay, so I think that makes it clear for everyone exactly what amendment you're proposing.
Thank you, ma'am.
Yep. And is there a second?
No, it's fine. Okay, we'll vote on the minutes as amended. All in favor?
Aye.
Great. All opposed? Any abstentions? Okay.
I wasn't here for the
Attorney
meeting,
Steer-
so abstain.
Yep. Attorney Steer abstains. Anybody on Zoom? that needs to abstain? Captain Party? Okay. Okay, all right. Thank you. All right. All right, moving on to item 4, subcommittee reports. Senator Flaxen.
Just run them.
All right. Police response to crimes of family violence. You all should have in your packet updated language and recommendations to date. And I'll turn it over to Chief Fox.
Thank you, ma'am. On page 12, you will see the language that was discussed the last time we were together, which is seeking largely based on Connecticut General Statute 54-1R, that is seeking to take what is currently in the statute and identify the location and therefore the appropriate law enforcement agency to take the identified complaints. So what you'll see at the top of page 12 in the new language, which is read in the copy that I'm looking at, is the identification of those offenses that can be investigated, where the person resides, where the person received the communication, or where the communication was initiated. And then the bullets that flow thereafter are the statutory requirements as they are identified in 54-1R. The jurisdictional language that follows for harassment or stalking in the second part of the new language in red is for harassment first, harassment second, stalking second. Those are investigatable and reportable, if you will, to the place where the communication originated or the place where it was received. To harken back to my comments from a moment ago, this is the core of that secondary discussion that I raised that I think might require a legislative review in the future. But as it stands right now, the members of my committee believe it appropriate to advance to this larger body the clarifying language that you see on page number 12 to reflect the law as it exists at present. And if you'd like me to pause there, I will, or if you'd like me to go on to the second modification.
Let's pause there, see if anybody has questions or comments. Thank you. Any questions or comments? Any on Zoom? No? Okay. All right. Okay. Hearing none. Let's move on to the second recommendation.
And thank you again. Beginning on page 20, onto page 21, onto page 22, and then thereafter the struck language at the bottom of page 22. You will see the language, huge shout out and credit to Mr. DeTuna and my co-chair, Karen Foley O'Connor, for really getting down into the weeds on this and parsing out the language very specifically. The language that my subcommittee is recommending for you is an update and a reflection of the current manner in which the GPS monitoring program works. I will tell you this program is confusing, I think, at the patrol level, and I think there and this language is going to help or may help to alleviate that. So what you see before you, which was presented to you again the last time we were together, at least in the discussion phase, 2021 and top of 22 reflects the language that had grown outdated at the bottom of 22. Thank you.
Thank you. Any questions or comments regarding this language from page 20 to 22? Yes, Representative Nuccio.
Thank you. So we're talking specifically here about the alert notification and GPS monitoring program that the state, like you mentioned, passed in 2023. I know in my initial meetings, they were talking about the rollout for this, and it was over several different years before it was actually in all towns and districts. Has this program been fully rolled out across the entire state at this point?
Let me defer to my co-chair or experts from judicial.
Yes, Representative, since October 1st, 25.
So as of October 1st of 25, it's now in every town.
Every court.
Okay, and I guess my question, I'm not on this subcommittee, I'm on a different one. And looking at this, my question is really, is this a standard program for domestic violence victims, or is this something that has to be requested by the victim in order to make sure the person has GPS monitoring?
There's a statute and there's statutory criteria. When a person comes to court on arraignment with a violation of protective order or any order of protection and matches a high level of risk, family relations counselors who work in the court and conduct those arraignments, those pre-arraignment screenings, will have a conversation with the prosecutor and let the judge know through our written reports that happen at arraignment that the person meets the statutory criteria, what type of alerts that victim wishes to receive if they want to participate.
Okay, so if I'm hearing you correctly, please correct me if I'm wrong. So you have to either have a high risk case or have somebody who's actually violated a protective order to be able to say, you know, I would like the person who violated me to have to wear a GPS.
So that's the statute. So there's statutory criteria.
Right.
Other serious domestics by our policy, we bring those to the attention of the prosecutor and the judge, especially if a victim wishes to have that level of protection. So there are other felonies, serious cases in our policy, but that is outside of the statute.
Can a victim request this?
Yes, they have a family violence victim advocate. They would do it through that person.
Everybody's heads are going.
It doesn't mean that they would get it granted though. So a victim can request it, but it does not mean that it's automatically granted in every case.
Okay.
And the statute is pretty clear which individuals were the program was meant which defendants the program was meant to be utilized for. And even though that is the kind of the bulk of the people that are on it, there are other types of offenses, especially serious felonies, where the court will put that condition on.
Okay, so I guess for a future, I would like to understand what it would look like if we were to expand the program. So if somebody felt like they were fearful of their life, that they could request the GPS monitoring, what that would mean legally, because we don't want to violate anybody else's rights, but also, you know, I hear a lot of stories from a lot of different people about repeat offenders and people who taunt and are in the area, like, you know, not necessarily something that I can call and you're going to arrest somebody on. But I think, you know, we're reaching a level of domestic violence in this state that I personally don't find as acceptable. And if we can find a way to roll out this GPS monitoring in a more aggressive manner to make sure that people are safe, I'd be very interested to hear what that plan looks like from a financial and a legislative perspective.
However we can help you.
I appreciate that. Thank you.
Okay, thank you, Representative Nuccio. Any other comments or questions regarding pages 20 to 22?
I have two very minor wordsmithing suggestions. So in the first paragraph, where we indicate providing a warning or notification to victims of domestic violence, that an offender is within certain proximity, could that read when an offender?
Yes.
Okay.
I'm sorry, if you could just repeat where that was?
In the first paragraph, fourth line down,
Thank you.
changing that to when. Then in the third paragraph, second line, for the exclusion zone placed around their residence and other identified locations.
Yeah. Is that acceptable, Chief Fox?
It is.
Okay.
The last paragraph with the underlines, I'm not sure in the first line that to the exclusion zone is needed wording.
So would you suggest in line 1, you're talking about last paragraph, line 1?
So it would read, in addition, there is also a buffer zone placed around the existing stationary / mobile exclusion zones.
So to eliminate to the exclusion zone and start in addition, there's also a buffer zone. Is that
Yes.
acceptable? Sure. We'll take out also. Okay, so take out to the exclusion zone. And also, so it would read, in addition, there is a buffer zone placed around the existing stationary mobile exclusion zones. Is that acceptable? I'm getting a yes from Karen. Chief?
I frankly don't find it easier to read, but it's not a hill that I would die on.
Okay. Right. I like the honesty. It's great. Thank you, Nancy. Any other questions or comments, corrections to this language? I'm also looking on Zoom and I just don't see any hands up, so I'm not ignoring you all, but. Okay, all right. Merritt, you look like do you have something? Okay, all right, sorry. I feel like okay, all right. Hearing no other questions or comments or corrections. Do we want to approve the updated language as amended? So moved. Any questions, discussion, comments? Okay, hearing none, I need a second if anyone, great, thank you. All in favor?
Aye.
Great, on Zoom, okay, any opposed or abstentions? I don't see any, great, awesome, all right. Okay, moving on to court-based issues subcommittee. Oh, I'm sorry. I skipped your update. We just did the recommendations. That's okay, my apologies. I skipped the actual update. I just got right down to the business. Sorry about that. Karen, I defer to you for the update for the subcommittee.
Great.
Sorry about that.
We want to thank the subcommittee and this full council for allowing us to get this language passed in July, because it allows us to get it out for training in the calendar that fits law enforcement. So thank you to everyone that helped with this. I just want to say that we are going to continue to meet. We want to look at, as we're talking about jurisdiction, we want to look at other statutes that need this same language. And also, what is also very confusing to law enforcement is that the statute relating to the full no contact orders also gives the option of a victim to make that complaint in where they live, whereas these others take that away. So we're going to be meeting to discuss and move forward some recommendations to the legislature to look at that and maybe keeping it all consistent, so it's not confusing for law enforcement and that victims have a place to go that's close to their home.
That's great. Thank you.
Thanks.
Any comments or questions for Karen? Apologies for skipping over the update. Representative Nuccio.
Thank you. In relation to continuing updates, I know there's been a lot of talk about the death of Carrie in, I believe, Winston. In Carrie's law, that's being looked at for what is perceived as gaps in the monitoring. I've gotten a lot of information on this. I've also had a lot of in-depth conversations with Representative Jay Case, who is representative of the area there. Are you guys going to be looking at what is being proposed there to see if that's something that fits within the guidelines of, I know we just did this current GPS update, but I think they're looking at additional risk behaviors by the offender. And if that's going to be something that we're going to be digging into in that subcommittee for evaluation for next session.
So
Yeah, I can take that.
Yeah.
So, I mean, I can take this. I know we CCDV and our member program that serves that area, Susan B. Anthony Project, are meeting with a group of individuals that are advocating for those changes. So I think the meeting's actually next week on Tuesday. So I think we'll have a better sense of what they're looking to do, and we can certainly bring that back to the subcommittees to update them and the full council for the next council meeting.
I appreciate that. I think that's good to understand what they're looking at. One of the things that I've kind of also struggled with when it comes to domestic violence, especially repeat offenders, is when we look at the bail system that we have in that, there is nothing in there that takes into consideration public safety. And, when we let somebody out on bail, is at a public safety risk. So it's something that I've been kind of talking to people about and pushing for like the last, I think you and I have had that conversation, Megan, that we have to at some point look at perpetrators of crime, especially domestic violence crime, to say what is the public safety risk and can we take that into consideration when posting or applying bail or bond, so I understand like the desire to kind of strengthen the need for that and look at making sure we're capturing people who have high risk behaviors and the likelihood of them reoffending or breaking a protective order. And that's why I asked about the expansion of the GPS. If there's behaviors that are seen or as troublesome, or anything that I think can help prevent a woman dying, I think it's something that, I'm all for. So.
Okay, thank you. Any comments or questions related or unrelated to that? Okay. All right. Okay, hearing none. Sorry, we're actually now moving on to court-based issues. Let's do the update first. Sorry about that, and then the recommendations.
Okay, I guess I'll take that.
Whoever wants to take it. Thank you, Merritt.
So for an update, we are now looking at the data that is collected regarding domestic violence offenses. Unfortunately, the data is really lagging. I mentioned this at the last court-based issues subcommittee that the latest crime reports that are available from the Department of Emergency Services and Public Protection are 2023. So it's really hard for us as a committee to make recommendations, especially when we're talking about DV dockets, risk assessments, the Family Violence Education Program, when we don't have actual data. So actually, my co-chair and I are going to be having a conversation with Joe. And we did talk about it at the last subcommittee meeting about collecting some data to see where we can recommend improvements, because I think right now we're not getting it. And as Representative Nuccio said, I think we're seeing an increase in domestic violence, and we really need to get to the bottom of it. So that's what we're taking on. Also, the Firearms Working Group has submitted a recommendation to our subcommittee, so we'll be exploring that as well.
Great. Any questions or comments for Merritt or the subcommittee? Just a comment on sort of what you're referencing in terms of the data and increases in domestic violence crimes. We did, there is like a NIBRS report that came out around overall crime and that is down, but the domestic violence crime actually within that report has increased. So although statewide crime is down, domestic violence crime increased in that report. And so CCADV has been working proactively with the Department of Emergency Services and Public Protection on that. They actually proactively reached out to us based on that data. So it's just kind of an update for all of you. And we'll work with them and others that it makes sense to try to figure out what's going on and ways that we can mitigate that moving forward. Mm-hmm. Oh, yes, Representative Nuccio.
Full of questions today.
This is good.
So what happens?
Why we're here.
So in relation to that, I looked at that report also, but what I couldn't seem to figure out is how much of that increase are repeat offenders. Do we have that data?
That's a good question. I don't know. We could have them come and present it. They might have, I don't know if Captain Maynard, you would know if they have, no. Okay.
I think that's an important thing to look at with this, because while we're seeing I would consider it a massive uptick. It's a big uptick in domestic violence. I know when I speak to troopers, a lot of what they're seeing is around the domestic violence and family violence kind of areas. So if there's a way to look at repeat offenders, this gets back exactly to, I'm literally like looping back and back, right? Like I think, repeat offenders, we should be slapping a GPS on them. I think repeat offenders, we should be looking at public safety when we're looking at releasing people on bail and bond. So trying to figure out, is this new domestic violence crime, or do we have people who are out there repeating? Is it a violation? You know, I think we really need to understand the uptick, what's driving it, and what we can do to kind of curtail it.
Those are valid points. And we can follow up and see if they can come to our next meeting and present on that data. So that would be good.
Perfect. Thank you.
Mark.
I wanted to thank the representative for her thoughtful questions, and on the emergency to deaths annual crime report. I think that draws data from law enforcement agencies concerning reports to law enforcement involving types of crime. So there isn't a recidivism component to it, as far as I know, because there are federal guidelines regarding how law enforcement agencies collect and report that information. So I don't think it's individual specific, it's incident specific. But I agree with the co-chair, that it would be great to learn more about that report and what we can, what information we can draw from it. The representative also is asking about, pretrial services, and I don't work in that area of the judicial branch, but I do know that there are risk and need assessments that are conducted to look at, static and dynamic factors involving the defendants, including number of prior arrests, number of prior holds in jail, and so on. That's used to sort of sort the individuals. And then there are factors involving domestic violence. And if that would be also beneficial, maybe court support services would be able to provide information just about the structure of that on other components too. I can't speak on behalf of that division, but I just think that the representative is asking very thoughtful questions about, how can we collect data, and does that data include, incidents reported to agencies, or does it involve individuals and their prior involvement with different systems? So
it's a valid point. Joe, wouldn't the judicial branch have the recidivism data?
I would say probably it'd be an ad hoc report. It'd be something that you'd have to ask specifically how many people that were arrested for domestic violence in 2025, how many had a prior case within X amount of time. I mean, sometimes people get arrested 10 years ago and then get arrested again. So maybe it's more of a proximity within a certain number of years. I think that is doable. It's just asking and having the resources to pull that data.
Do you mind, Megan?
Sure.
So I don't know how deep we have to dig on this. I will just tell you that I have heard several stories anecdotally from troopers and police officers of arresting somebody 3 times in one day. They get out on bail, they go back, they violate, they go back, they get bail again. At midnight, they're arresting the same person again for the 3rd time, right? Now, these are stories that I hear anecdotally, right? And I'm not the kind of person, I'm not going to act on a story, right? I would like to see, like, with this uptick that we're seeing, what are the instances that they are? If there is somebody that we're arresting 2-3 times for violating a protective order in the same day, there's something that needs to be corrected there, right? So it's something beyond just somebody who had a prior 10 years ago, right? So my concern is the uptick that we're seeing now, and what policies and procedures we may have in place that are enabling that person to go back out and repeat offend, especially if it's within the same day, within the same 3 days, within the same week. That's where my bigger concern is, not necessarily somebody from 10 years ago, but somebody within the last 6 to 9 months.
With data, you have to put the parameters around it, because they're searching with code, right? And
Right.
we have to give them the kind of the guidelines and the blueprint for them to give us the accurate information back. So recidivism has a lot of different connotations. It could be anytime, it could be anytime in the past ever, it could be in the short term. It really depends on what you're looking to accomplish. So in CSSD, we have judicial branch CSSD, we have pretrial services, which is the individuals who deal with bail and those types of things. And we have family services, who does more of the pre-arraignment screens with risk assessments and things. So there's certainly the ability, if we have an ask for data, we should just be very mindful of making it specific, so that the people who have to pull that data in and the programmers can do it in a reasonable amount of time.
Attorney Steer.
Thank you. At arraignment, prosecutors have available the intake assessment report from Family Relations, and I know in New London they do a terrific job of giving us a history. In fact, they will tell us how many previous domestic violence arrests an individual has had, whether it's with the same partner, and then we can compare that with the regular criminal history that's provided at time of arraignment and also the input from the bail commissioner. So we do have quite a bit of information available at the time of arraignment. It's extremely helpful. Family Relations is just wonderful in what they provide. We couldn't operate without it.
I think what the representative is asking is how many people are at the time of arrest or during their first interview with pretrial services, how many times they were having a bond, how many times they made that bond, and if they did they get rearrested, and how quickly that happened. That's a different discussion. I think you're really looking at somebody getting arrested repeatedly within a really quick period of time after either the police have set a bond or the pretrial services has. That's what I'm hearing.
I think it's a combination, right? Because at that point, for me, the second time, somebody's breaking a PO, you slap a GPS on them. You're because at that point, that person is escalating, right? You have someone who's escalating, continuing to break protective orders. You're heading for imminent danger for that woman and family or male or whatever. You're headed for imminent danger. And what are we doing to kind of slow that roll, right? So
the current statute, those are the cases that we would inform the prosecutor and the judge that these are the individuals who meet the statutory criteria for alert notification GPS. By the time what you're talking about, those individuals more likely than not are going to be designated as high risk. For the risk assessments are, I'm not going to spend out, it'd be a lot of conversation, but suffice to say, those are the cases that we're concerned about too. The people who are non-compliant, that aren't listening to the court's orders, those are individuals that are already in this program and in this system by the statute that the legislature passed. Increasing that to those that don't have violations of protective order, increasing it to people who have maybe misdemeanor charges, that's another discussion. And I think that's what potentially that individual is really asking, is having a larger swath of cases be eligible or meeting the statutory criteria, because there'd be a new statute. And really for us is what's the financial ramifications of that. And really for me, the biggest thing that never has been really brought to bear is the police resources. Because I know from our program, we're asking law enforcement to do a lot of checking on victims, making sure that they're okay, and really responding to the alerts. And if you're gonna have, a great deal more people on this program, that's going to impact police resources. Just
absolutely, absolutely.
I've had the pleasure of going around the state, talking to every chief and talking about the program just as it expanded. And that was really their biggest concern, even with the smaller number of individuals on it, is really being able to meet that need in the community while also dealing with other really serious types of events that happen in every town across the state. So there'd have to be some discussion about the impact across the board.
Absolutely. The only other question I have in relation to that then is the program that you're talking about, if there are like somebody that's back the second time in that, is that judge optional or is that judge mandatory? So like we see this and at that point, this is the next procedure, or does a judge have the ability at that point to decide whether or not they want to do it?
Yeah, I mean, I think always the judge has discretion about what conditions are placed. I mean, I think that is rooted in, I believe, in statute. I'm not a lawyer or a judge, but I know from my discussions, I think that is certainly something. I think a judge has the ability to go around the statute too and put other types of cases on alert notification GPS. We had a judge make that ruling. So there's a lot of different factors. One that is really necessary is, what is the victim looking to do? Some victims don't want police involvement. Some victims don't want alerts. Some victims don't want to carry the device, and have that mobile zone around that person. So I think that there's a balance that needs to happen in terms of what cases get put on. Sometimes victims don't want a protective order, or full no contact, any protective order. So I think we're guided by a lot of different factors when we bring this up. And I know the prosecutors as well. There's a lot of factors. There's a lot of individuals that are held on bond with the condition of alert notification, GPS. I think 153 the last time I looked a couple days ago. So the judges are putting people having high bonds with that condition. So if they get out, they do have alert notification. They have the device, but the discretion of the court, I think, is rudimentary, right? I mean, Sarah would know better.
Absolutely. So it'd be the
Thanks
prosecutor.
for saving me.
No, thank you for all your input. It's definitely the discretion of the judge and persuasive impact of the prosecutor, hopefully.
Chief Fox.
Yeah, and I just want to seize on, you'll be shocked that I just want to seize on the police part of this, right? But at the risk of piling on, I very much appreciate that one shout out in there. We have to appreciate, I can certainly support the expanded use of the program. I think there are recent incidents and historical concerns that we're all as a group very cognizant of. But the downstream implication of expanding this or any other program is that you're now going to put additional demands on the first responders. And that's going to result in, frankly, it has the potential to result in lower response times. And I hate to say this, but I fear that sometimes it has an implication on the quality of the response because there are just competing demands for service. And, I have people running from call to call to call to call to call. And sometimes I worry about corners being cut. We strive internally and we strive as a profession to make sure that that is not the norm, but there would be a downstream impact of this decision. And the resources discussion unfortunately would be a piece that we'd need to air. Thank you.
And I think the idea of adding more defendants on the program has been discussed for a very long time. So I think it just is having either some sort of feasibility study or having everyone get together and kind of really talk about what the impact would be, real numbers. And the difficulty is I can give you real numbers. They're going to be high. And that's just the reality of it. So all high risk domestic violence offenders, there's probably about 7,000 a year. And so that's just a lot. And a lot of times what happens is we give these kind of large things and not in a way to derail, but to give the reality of the situation. But there's also potentially other ways to handle this issue. So I think it's a worthy discussion and it's something I'm sure Megan will be emailing me about.
Sure. Thank you, Joe. Karen.
Just Tammy, because I too want to talk about the police part of it. In that police, in their role in setting bonds, there's a concern that the bonds need to be to ensure their appearance in court and not punitive. And I just want to add that the conditions of release, which is the document that goes when we release somebody from law enforcement. I just said we, sorry. I still say we, but that when they're released, they have conditions. It's required on that sheet that the police department call a bail commissioner to set that bond. And so if you're going to do a data dive, it might behoove us to look at how often a bail commissioner sets that bond. Because sometimes, and I don't know if that's changed, I haven't been in that seat for a long time, but sometimes the bail commissioners don't get there and they end up getting bonded out by law enforcement. Do you want to add to that, Chief?
Well, I fear this may be the third rail in the discussion, especially in this building, but we will all remember, I'm sure, that we made a collective decision within the state to substantially alter the bond formula a few years ago, substantially alter the bond formula. So we're having a discussion specific to domestic violence, and I understand that, but the days of a bond being a bond are not what they were when any of us started.
Thank you, Chief Fox. State's Attorney Steer, I wanted to go back to, you had mentioned how New London court operates. Do you have any knowledge that other courts operate similarly?
I don't. Joe might know if that's a standard amount of information that goes into the assessment reports.
Yeah, I mean, our role is to assist the prosecutor and the judge relative to if a person is eligible for pretrial diversionary opportunities. That's part of our statute. And to let the court know who does not meet that eligibility, we have to give the prior number of cases that the person has gone through for family services. So we do give that information for that purpose. So in every arraignment report, the judge is going to get whether the person's eligible and the reasons why or why not they might not be. And usually the reason they would not be is because they've had either the family violence education program before in the past, or they've had multiple opportunities or just multiple DV cases. And so that we want to make sure the prosecutor and the judge knows the cases that family services is going to take, which are really the first or second time offenders that are eligible for a family violence ed program. And we also want to let them know the cases that are beyond the scope of that opportunity. And that happens in every report.
That's enormously helpful. And there's another piece of information that's helpful too, and that's the LAP. Because if you look at the LAP form, it'll say how many times that this type of violence has happened in the past and may not have been reported. And so that's an important information to know when you're discussing whether somebody might be a safety risk to the individual or to the public at large.
And I guess one last comment to kind of address Joe's, there might be other ways to address this issue. I think CCADV would advocate for domestic violence dockets in every court. And we would suggest that would be the better use of the money and investment. So I just want to go on record with that. I know Merritt's group is looking at that, but I just wanted to make that really clear for everybody. Okay. Any other discussion before we get to your recommendations? Okay. All right, Merritt, take it away.
Okay, we have 3 recommendations for the council. The first one we discussed at the last council meeting. The subcommittee believes that when Clean Slate was passed, they intended for all domestic violence crimes to be included. However, through the implementation, through the state police, they developed their database to deal with the Clean Slate, and they go by 46B38H, which is a limiting list of domestic violence crimes. So the committee identified, and you'll see the following crimes: assault third, threatening first, unlawful restraint first, unlawful restraint second, custodial interference first, custodial interference second, criminal mischief first, second, and third, electronic stalking, interfering with an emergency call, and violating conditions of release first and second. So if the intent was to incorporate all domestic violence offenses, it's the subcommittee's belief these offenses need to be added to 46B38H, so they're incorporated into not being erased. I know that Special Act 26-8 may change some of this. That's the law that is requiring this subcommittee, along with the others. I think it's the Chief Court Administrator and some others, to develop and implement a program of identifying domestic violence offenses universally. So that may change all of this, but I think that's going to take time. And I think this is the best way for us to incorporate the crimes so they're not erased. And we understand that it's happening now. Assault thirds are being erased because they're not being classified as domestic violence. And so it's a problem right now that we need to address. So that is our recommendation, that these crimes be added to 46B38H.
Okay, any questions, comments? Yes, Johanna.
Hi. I just want to put on the record that I believe that the Public Defender's Office was the only vote against this. And the reason for our voting against this is because the Clean Slate Act was such a monumental piece of work. It was substantive. It was it's a large piece of work, which makes a large difference in a lot of people's lives. And it was really strange and unclear how something like disorderly conduct made it on the list, but something else, like unlawful restraint in the first, did not. So it was confusing. We were wondering what the legislative intent was behind that. And also, the concern also from the public defender's office is that we are tinkering with this piece of legislation that has made such a difference. And if we start doing that, then maybe it comes unraveled at some point. We would prefer if we could wait to see what happens with that special act that Merritt was speaking about. But we've already made our claims. We did vote no at the time. We voted not to take a vote and to get more information, and then voted against it. And we will be doing the same today. And I just want to get that on the record. Thank you.
Thank you. Any other questions or comments? Okay. Okay, I guess we'll move forward with the recommendation, and I'll just ask for a motion. Any discussion? All in favor?
Aye.
Aye. I see ayes on Zoom. Opposed?
Nay.
Johanna, any abstentions? Okay, all right, moving on.
Okay, the second recommendation was briefly discussed at the last council meeting. But when
One at a time.
it's come to our attention that when a standing criminal protective order has been issued, and especially in cases now that we see so many pardons, the pardons are being denied, and if there's a standing criminal protective order in effect, and then that causes the person to then go to the court to try to vacate that protective order. The problem is that victims are not getting notified when attempts are being made to modify or vacate that standing criminal protective order. Right now, victims can register for notification of certain events with the Office of Victim Services or the Department of Corrections. And there's a form that victims fill out to do that notification. There's also a form that a person that's applying for certain for a pardon, for parole release, they're filling out the form. They must notify OVS and DOC, and then DOC and OVS in turn notify the victim. We would like that form modified. We have spoken to judicial to include when a person files a motion to vacate or modify a standing criminal protective order. I've talked to Mark about that. Judicial thinks that they can do this pretty seamlessly. It's just a matter of adding another little box to the form. So they're amenable to doing that, and I thank you. We did submit language. We're not married to that language, but it was just a way for everybody to understand it. So even though you see language here, the expectation is that if the council accepts the recommendation, that they then take over with that and the legislative aids. So you do have language, but that's really just so everybody can understand it. And so that's what this recommendation is accomplishing.
Great, thank you for that clarification. And it's just as a reminder, we had agreed after our first year that any legislative proposals would then go to sort of all the legislative liaisons to work out any final language rather than go through the council, because I think we had a lot of confusion and some legislative liaisons last year were able to read it, some weren't. So we're going to make sure that that's a really collaborative approach this year. So I just wanted to add the context to Merritt's comments for that. Any questions, comments, clarifications on this recommendation on number 2? Anybody on Zoom? No, you all look great, Sal. Okay, all right. So I'll move for a motion to approve recommendation number 2 from the court-based issues subcommittee.
So moved. Second.
Great. Any discussion? Hearing none, seeing none. All in favor?
Aye.
Aye. Any opposed? Abstentions? Great. Thank you.
Okay, our
Okay,
final
move on.
recommendation.
Yeah.
There is an inconsistency. This was brought to our attention, actually by a victim, the father of a victim. In the Freedom of Information statutes, regarding the confidentiality of the name and address of a victim, and then it lists a victim of sex assault, and it lists a bunch of statutes, voyeurism, risk of injury, impairing the morals of a child, family violence, crimes. So that information is protected in a couple of different statutes, but it's inconsistent. In one statute, it's just the name and address. In another statute, it's the name, address, or other identifying information. That other identifying information becomes really important, especially when we're talking about things that are being published in the paper and things like that. You know, identifying the gender, whether the person is a student, an employee, that really would expose that victim in a way that I think is very unfair when you get it from one statute, but not the other. These statutes are 1-210 and 1-215. So we're just asking that other identifying information be added to 1-210 to be consistent in the confidentiality protections for victims.
Any questions or clarifications, comments? I guess I have one question.
Yep.
Do we, in all of these statutes, do they have to follow the PII statute for the state of Connecticut?
Can you say that?
Like the personally identifying information statute, the statutes that the state of Connecticut has? Do they have to follow the same statute? So there are statutes for the state of Connecticut for personally identifying information. So should
don't know the
we
answer
look
to
at those and make sure that they are consistent?
Do you know what that statute number is?
I don't know the statute number, but I can get it for you.
Okay.
I only know this from my cybersecurity training that we just had to take, and we had to go through all the Connecticut statute. We had to look up, well, and at least for our insurance, we had to look up all the, make sure we were in compliance with the Connecticut statutes regarding personally identifying information. So I can get the statutes for you.
Yeah, I don't know how that works with these because these.
I don't, yeah,
Yeah.
I don't know either. I don't know if you have to comply with it or not. I know.
Is the statute you're referring to the one that allows the requester to identify and obtain broader information if they're asking about themselves? That's the context I've heard PII referenced in previously. Because if that's the case, then I don't think that would be the problem here.
Yeah.
We're concerned about, if that's the case, I think that.
I think it's for like, so, because we have to make sure we're in compliance if there's like a breach of other people's information, right? And we have to make sure that we sort of go through and make sure anything that's listed in the Connecticut statutes that's considered PII is then relayed to that if there's a breach, right? So I'm just wondering if this has to follow the same extensive, no. I can look up the statute and send it to you. I'm just curious because there's a list of things that you have to make sure of
I
in
don't-
that statute.
I don't think so. And the reason why is we're talking about records of law enforcement, either being held by law enforcement themselves or by the court.
Okay.
And so I don't think those records would contain a lot of PII except for the name and address and maybe date of birth. Am I wrong?
I think
I think the statute itself is specifically targeted to identity theft and that type of thing.
Yeah.
That's what's prohibited. And so I don't think it really affects that. at
Yeah, I
all.
don't think it does either. Yeah.
Okay. I can send it over just to make sure.
Yeah. Okay.
I would support generally any clarification that this group feels that they can prompt as to what may be well-intentioned, but nevertheless is some ambiguity in this area.
Mhm.
We get FOIA requests regularly and we wrestle with statutes all the time and we get into, social security number. Okay, that's pretty easy. Telephone number, address, past address, gender issues, If this committee wanted to tackle something like that, I think we'd certainly support it.
Okay, great. And I'll follow up with you, Mara, on those
Okay.
statutes too.
Okay.
Okay. Any other questions or comments regarding this recommendation? Karen?
I do support this, protecting the victim's identity. However, this is going to create more confusion. When you're talking about a domestic violence case, you're going to want to identify the relationship. And I think for the most part, the general rule is that you don't say what their relationship is, but that they are, meet the definition of family or household member. And I think to speak to the dynamics of that relationship, it's hard. It's hard to, if you can't say it's, a parent offending a child, or that they were married, or that they had a child, like talk about those pieces that are indicators of high risk. So I 100% support the concept, but I think it comes with more difficulty in law enforcement being able to articulate the dangers of a certain situation, because it gets hard to write. Even when we have two, if it's a dual, you got victim one, victim two, it starts to get, they're really hard to read. I don't know that we're going to be able to give the true benefit of what the danger is if we start getting really granular on no identity.
Just to clarify, Karen, this is, so it would be redacted, not that it can't be in there, but before that information is released, it would have to be redacted. So it's not that you can't put it in the report, but if somebody then requests that report, that identifying information would be redacted from the public. That's what we're talking about. So it's not that it wouldn't be in the report.
So I will say I've heard from different areas that different jurisdictions want their warrants and things done the way that jurisdiction wants it done. And I know that I've seen somebody come to me with, help with how am I going to do this, that they don't even want it in the report. Maybe the concern is that they don't want to be doing redacting on the judicial level. Maybe it's the concern that within a police department that they don't want to, they're concerned about the redacting, like what if we miss it? So I know that there has been direction to law enforcement that they want things coming to the court that are clean with the way the statute stands now. And right now there is an effort to not identify that, like, so they're already kind of doing that. Chief, would you support me on that? Like,
Yes, and the example you're describing is, don't give up the victim's address, but I have to provide the location where the event occurred. It goes out in daily logs. It goes out in an effort to be transparent to the public. So we went to an address and a domestic violence arrest was made there. Unless the person happened to be a visitor, I can't give up the home address of the victim, but I gave up the address where it occurred. There's holes in the way that in the mandates.
so with that being said, like, that's my concern, first and foremost, that law enforcement is able to truly articulate the risk, right? And what the relationship is. And the second piece is if something like that occurs where we're giving up a location and something happens, and looking at liability on the police department for, well, why'd you give up that location? So I mean, I think it's just getting tough. It's getting tight, but I agree with you. And I will vote yes to looking at this. But I just have concerns about that related to victims and to the protection of law enforcement trying to do the best job with all good intentions.
Mm-hmm. And I think from a practical standpoint, right now, the inconsistency, you have the courts doing one thing and you have law enforcement doing another. So what protection are we really offering is the question. So it's either we don't have protection or we do, but we need to be consistent about the protection that we're offering.
Agreed, and consistency from area to area.
Mm-hmm.
Well, that's another reason to have DV dockets too, consistency from area to area. Okay, any other comments regarding this recommendation? Okay, no other comments, then I will ask for a motion to approve recommendation number 3. Great. Is there a
Second.
great? Any other further discussion? Hearing and seeing none. All in favor?
Aye.
Aye. On Zoom, everybody's aye. Any opposed? Abstentions? Okay. All right, great. Thank you so much. Okay, moving on to the next agenda item, firearm seizure and compliance working group update. There is a sorry, that's under other business, your next handout. So Shauna, are you given the update for that?
Yes.
Okay, great.
So at our last meeting on June 17th, we voted to move recommendations forward to either the court-based issues subcommittee or the model policy subcommittee. And then those subcommittees would then vote on the recommendations themselves and whether they'd like them to move forward to the larger council. I wasn't present at the last court-based issues meeting, but it's my understanding that there were not enough members present to have a vote. Likewise, the recommendation we voted to move forward to the model policy subcommittee will be voted on next year as they operate on a different calendar than we do. And our final recommendation did not fit neatly within either of the subcommittees, so the group voted and agreed to bring it straight to the larger council for a vote. So I'll go through it today. I don't know if you want to do that vote today or not, but so to be clear, our group only voted to move these forward to respective groups, and none of them have been voted on further. So that all being said, we agreed as a group that this is a multi-pronged approach and that no one recommendation alone is going to fix the firearm seizure and compliance issue. That instead, it will take several steps from key stakeholders to improve and strengthen the procedures currently in place for firearm seizure and compliance. So our recommendations for the court-based issues subcommittee, there were two separate options for consideration. And to be clear, we don't believe that either one of these are form recommendations, a modification of a form. We don't believe that either of these recommendations will fix this issue, rather just close the loop regarding compliance and allow the court a way to track it. We also felt that requiring the defendant to acknowledge their responsibility was important and couldn't hurt. So that being said, the first one is to add a checkbox to the condition of release form that would then be verified by bail that a defendant has signed the DPS 332C compliance statement. So this is a compliance form that's already in use that police departments can have defendants sign when guns are seized. And although the use of this form is not consistent, this is why the model policy subcommittee updated language around the use of this form. The idea behind this is so that there's a condition of release by the court that the defendant cannot have guns. So if the Special Licensing and Firearms Unit reports noncompliance, assuming the backlog is not as long, which we'll get to, the defendant could be in violation of the conditions of release with the court and not have to wait for a police investigation. There was a concern that this would be a resource and/or capacity issue for bail. So we did bring bail into the meeting to confirm this, and they said they would not be able to comply with this without a large fiscal note. That's the first recommendation. I don't know if we want to pause after each of them.
Yeah, I think pause and we'll just to be clear, we're discussing them today, but these have to be brought to the subcommittees and then discussed further. And I think for Shauna, the one you mentioned that should come to the full council, we can certainly discuss it today, but let's bring actual, written reports to the full council for like anything further. So that's fine. Any questions for Shauna or comments, discussion? It's just discussion today, nothing to be voted on. Okay. I don't see any in the room, Shauna, and I don't see any on Zoom, so.
Okay.
Going.
So our next recommendation for the court-based issues subcommittee was to modify the JDCL 98 form to add a signature line and a carbon copy. So this was as an alternative to the bail recommendation because bail indicated that it would be a resource issue for them. This modification was pitched instead. So this form is what's given to defendants at arraignment when they are subject to a protective order. There are instructions there regarding firearm surrender. So the modification of this form would serve as a written acknowledgement from the defendant that they may have to surrender their firearms as a result of being subject to an order of protection. This option takes bail out of the equation, as the defendant could sign this in front of the judge at the issuance of the protective order. This would solely serve as an acknowledgement, not an admission of having firearms, just that the defendant understands that if they have firearms, they understand what they have to do. A copy of this could then be given to the defendant, the state, and the clerk's office, and it could also be used as a condition of release with the court. Police in the room noted that this could also strengthen their warrant application if there's a signed acknowledgement, as then they don't have to wait for a transcript. This would also cover some of the gap in time between law enforcement receiving the compliance notice from Special Licensing and Firearms Unit, which takes about a week, assuming the defendant is even living at that home anymore, as they could be subject to an order of protection that removes them from the home where they would typically receive mail. So that's the second one.
Any questions, comments? I'm not seeing it. I'm just looking around. I'm not looking at anybody in particular. I'm just looking around. Sorry. Okay, I keep going.
And
All right.
Wait,
and
don't hold on. Joe
I
has
think
a
the
comment.
vast majority of the conversation was the backlog, right? And, you know, as officers of the court, we need to find out if that person truly is non-compliant. And without the ability to check a web, some sort of a system, or it makes it very difficult for any condition of release to be enforced. And not that I'm looking at Johanna, but the reality is that if that person's in front of the judge and we can't give that judge accurate, timely information about whether that person complied or not, it makes it very difficult. And I'm not disagreeing with what Shauna's putting forth. My backdrop has always been, we need to fix that problem first, or somehow fix that problem so that the court can have realistic, verifiable information. That's why I'm not objecting, because I think everything that she says is worthy if we can validate it at some other point or in real time. If we can't, I think that we're going to have a lot of continuances and a lot of different things that really is going to create multiple issues rather than solve them.
Okay, thank you for that, Shauna. I do have another comment, so hold on, from Karen.
I just wanted to mention, because I did join one of their working group meetings, we did confirm that there is not a backlog with the compliances going out to the police departments to be acted upon. And they're coming back in a timely manner. The backlog is in putting the results of those compliance checks. They're a good 2-3 months behind.
Okay.
If I could just.
So yes, no, sorry, Johanna.
This is all information that I'm going to be taking to, and I was present at the last meeting. We weren't able to vote or do anything with it, and it was presented for the first time. I do need to discuss this. We started discussions. I need to discuss this with the chief public defender, but just off the top of my head, and I know that the working group has been working hard because there's a member on the board who represents the Connecticut Criminal Defense Lawyers Association. He's been letting me know what's been going on. I know they've been doing a lot of work, but checking a box and signing a piece of paper, I'm not sure what we're really getting at here when defendants stand in front of the court and the court says to them already, I am telling you, if you have any guns or weapons, you need to turn those in. They've already been warned. They've been told exactly what's going to happen. It's sort of same.
Okay, thank you for that, Karen.
I just wanted to speak to the fact that if we're looking at a true abuser, their number one concern at the time of an order, I think, is being separated from the person that they're controlling, and may not be taking in everything that's coming at their way. That separation piece is big. So that's why I supported this, that if they're going to have something on a piece of paper that they can read when they're.
I believe it is on the protective order. Am I correct? It's there. It's in writing. It's there with all the other conditions that they have to read later. So.
I don't know, Shauna, if did you want to respond to Johanna's comment?
Yeah, as I noted, the police in the room also noted this could strengthen their warrant application if there's a signed acknowledgement, as then they wouldn't have to wait for a transcript necessarily. So it just improves that gap in time as well.
Okay.
I just have a
Oh,
question.
yeah.
Are there going to be instructions as to when and how they have to do all this? I mean, there needs to be a lot more to it than just telling them this has to be done. If we're going to get into that area, we need to be more specific, I think.
Shauna, did you want to respond to that?
Yeah, we didn't necessarily flesh out the details of what those instructions and that language would look like.
I think the point is that these have to go still to the subcommittees, and I think some of that work, correct me if I'm wrong, Shauna, would happen at the subcommittee level. I think the firearms working group has done a lot of like initial really good work, and then now has to go to these to this respective subcommittee. And so those are the types of things that at the subcommittee level we would hope would be discussed, worked out. Before coming to the full council. Is that accurate, Shauna?
Correct. That's my understanding.
Yeah. Although since I'm on a roll, if you don't want to do this, then DV dockets is also a great alternative. So there's been 3 reasons for the legislators in the room to invest money in DV dockets across the state. I hope that's been made pretty clear. Okay. So, so sure, Senator.
I just have to respond to that comment. DV dockets could be created by the state agencies. The prosecutors and various judicial districts could choose to work with judicial to make these dockets. The legislature does not have to direct these things to happen. So there's lots of things to put on the legislature. This is not one of them.
Yes, in response to that, I would just say if the agencies don't do it on their own, the legislature does have the power to
We could
direct.
strongly encourage them. Yes, yes. Yes.
Okay, all right. Okay, moving on. So
I still have 2 more recommendations.
A couple more. Any other comments or questions for the first 2? Okay, Shauna, keep going.
Okay. So this next one is for the Model Policy Subcommittee, which is to enhance follow-up by law enforcement by adding a statement to the model policy indicating that, quote, each department shall create follow-up procedure for seizing firearms and investigating noncompliance. So Karen attended our last group and informed the group of the changes that were made to the model policy last year, which address a lot of the investigation issues the group had discussed in the past, including asking offenders to sign the DPS 332C form regarding compliance. The group also discussed potentially adding language around each department designating a compliance officer for follow-up investigation. So that's all for that one. And that language is not necessarily set in stone either.
Okay, any comments or questions on this recommendation? And again, the subcommittees are going to get these recommendations first. So this is just for discussion today. Okay, I'm not seeing any in the room. I'm not seeing any on Zoom. So Shauna, you want to move to your last recommendation? And this is the one that would come directly to the full council, just for clarification. So it's just discussion, but you'll get language ahead of time for it to be discussed at a full council meeting.
Correct. So to address some of the concerns around the backlog from the Special Licensing and Firearms Unit, we voted as a group to move forward that we'd like to see more resources for the Special Licensing and Firearms Unit. So as was already mentioned, there are very few people working in this unit who have the very important task of ensuring and tracking compliance, and their database backlog is 3 to 4 months. Now that backlog includes from the time a person is arraigned, notice is sent to the police department, follow-up investigation is communicated back to the Special Licensing Unit or not, and that information is available in the system to be verified by the courts. So that whole process, the backlog is about 3 to 4 months. So whether it's more staff or better computer systems, the group agreed that the special licensing unit needs more resources to be able to address this backlog and get information distributed in a more timely manner.
Shauna, if you could just repeat the full title of the unit again.
The Special Licensing and Firearms Unit.
Thank you.
You're welcome.
Any questions or comments regarding this? So this is the recommendation that will be discussed at the full council in the future. I don't know if Alina, you want to mention your grant program, because it sounds like the special licensing firearm unit could take advantage of it. I don't know if that's a good thing to mention here at this meeting or not, but
I'm sorry, was that directed at me? I could
yes,
barely hear what you were saying.
based on the backlog, it sounds like either equipment or staffing. I didn't know if it would be appropriate for you to just sort of highlight some of the grant programs that.
Right. I was thinking that when I was hearing that we just at OPM in our division, there are several federal grants that could, in fact, depending on the exact nature of the program, could be eligible for. So I'd be certainly, we just, our Burn JAG program that has been on hold for quite some time, we just opened up funding. So certainly be happy to have a conversation about that particular program to see if it could be the program would be aligned with the grant.
Great. Thank you. Sorry for putting you on the spot there. Any other questions or comments for Shauna for the last recommendation? Okay. All right. Okay. I don't see any on Zoom. I don't see any in person. So Shauna, thank you very much. So those will move forward to subcommittees, and then the last one will move forward to the full council in the future at future meetings. So moving on to the next agenda item under other business, you all have a presentation that was attached to your packets, or if you have them in person, the handout regarding the supervised diversionary program roundtable recap. Joe, are you taking the lead on this one?
I believe so, but I'm
Great.
fearful of mentioning it because I might hear domestic violence dockets.
Oh, I guess you did it for me. That's great. I'm glad that the agency is doing it for me now. Thank you.
So if people remember, this was a recommendation of the court-based subcommittee 2 years ago, maybe. There was legislation proposed, and we came back and we made some recommendations to the committee. And in preparation for January, I was able to put a presentation together and lead a guided discussion as part of the DV roundtable that was conducted in May of this year. It was regarding the supervised diversionary program cases that have domestic violence charges related and within that case. It was a really robust and lively discussion. Our attendance was significant. We had GA prosecutors, we had public defenders, victim advocates, CSSD Family Services attended, an individual from adult probation, and some members of our contracted provider network that does the supervised diversionary program evaluation. So we had the right people in the room. And I went through the PowerPoint, and we talked about many of the issues regarding supervised diversionary program, the challenges when there's domestic violence charges, and really the issue, the central issue is whether domestic violence intervention is appropriate for addition to those supervised diversionary program requests. I think that we were able to have a number of pretty solid potential solutions. I think there was some validity and a great deal of possibility for some of them. And where I'm going to go back to the court-based subcommittee. I think what I'd like to do is to recommend that one, we were going to have a pretty significant training that would be sponsored by the branch and the Chief State's Attorney's Office. That was one of our major recommendations. I think that from a lot of the discussion, I believe that is still really valid. I think that that's something that would be a good use of our resources, is to have a really robust discussion and training about the supervised diversionary program and domestic violence. And so I think that could go forward in the fall. And at the same time, I think that based on some of the discussions we had, I think a group of the participants or maybe individuals within the court-based subcommittee can really get together and come up with some really great recommendations about potential legislative changes that I think would work within the framework of what we're trying to accomplish. So I think a two-prong approach within a very short period of time would be what I would recommend. I think that we can certainly have some good recommendations for when we make the votes in December. So I'm not sure when the court-based the court-based subcommittee meeting is, because I wasn't there the last time I was on vacation. So do we have something relatively soon?
In August, I don't have a date. 11th, August 11th.
And really I want to thank everyone for the discussion. I mean, that's really, I've said this a few times, but that's really why this body exists. I mean, to have that subcommittee where we have people from all different courts. We had the public defender, we had victim advocates, we had the state, we had the prosecutors. I think it was just a really good ability to really talk about something that is seemingly not complex, but there are complexities within it, especially for the individuals who are on supervised diversionary program and some of the mental health challenges they have. But at the end of the day, I think we have a few good leads to make some good recommendations and hopefully some solutions to the problem.
Great. Thank you, Joe. And I just want to also thank Shauna and Michael, because they did a lot of great work for that, to make that discussion happen too. And it was a really great discussion. One follow-up question, did we land on training for judges in that discussion as well? I know it was talked about.
I think what we were going to do is when the judicial branch and the chief state's attorney's training, or whatever we call it, judges would be invited.
Okay, thank you. Any other comments or questions regarding supervised diversionary roundtable and update? I don't see any on Zoom. I don't see any here. Okay, great. Okay. I really last minute thing, I actually asked Mark just to kind of give a quick and under other business, just to kind of update on and share a possible resource to all of us. Doesn't mean that we have to take advantage of it, but it's out there in case we want or need it. And then we'll move into the timeline for the report. So Mark, you want to?
Thank you, Madam Chair. Yes. I know from the very beginning of the formation of this group, we've talked about how to tap into resources for data analysis and evaluation. And Ken Barone contacted me from UConn Institute for Municipal and Regional Policy regarding a Northeastern University PhD candidate who has worked extensively with an advisory board that Ken presents to. And that this candidate, combined with professors who oversee her work, has done pretty extensive work on different research, data analysis and evaluation projects. And the candidate introduced interest in supporting work here. In fact, she shared a working paper she had done that involved data analysis of NIBRS data, or national crime data, involving intimate partner violence, I was remembering, from 1998 to 2019. She was looking at correlations between jurisdictions that had substance use treatment facilities and substance-involved intimate partner violence crimes. And looking for a correlation between the location of those facilities and some trends in IPV crime. So that was interesting to see, given our discussion today. So I connected the student with Megan just to see if there might be some alignment regarding some data analysis projects she and her professors could take on. Alignment with the timeframes that we have for areas we want to dive into. We don't know yet capacity and what we would prioritize and time frame, but it's a resource that we didn't know was available to us. What I found was favorable in talking to the student is her prior experience with Connecticut, with a state advisory board and commission. So it looks like conversations will occur to identify any opportunity for alignment, and we can certainly keep the group apprised about any opportunities that emerge.
Thank you for that update. And as your subcommittees are working on things, if you do have ideas for projects, please bring them to the full council and we can assess capacity with her. But I think it's a great resource, something that, we don't necessarily have the funding to fund, and she's willing to do it without that. So, okay, moving on to discussion of the annual report timeline. So, I know it sounds crazy that we're already discussing something that has to be voted on in December, but just to be clear in terms of timelines, so we would want all of the recommendations, ideally, the drafts of them, to be ready to rock and roll for the October meeting. In an ideal world, I'm looking around, seeing if that's realistic, and I'm not, I don't know. Yeah, in addition to what we already voted on today. So anything we voted on today will move forward into that report. Anything additional, hopefully we will be able to look at the full council meeting in October. We want to be able to give co-chairs enough time to be able to draft and review. So we'd want to give them until like November 13th to be able to look it over, make any edits or anything like that. We'd want the full report to go out by the end of November to everybody. I say the end of November because there's Thanksgiving in there. So I think it'll either go out before or after Thanksgiving. So either between the 25th and the 30th for folks to just have and review, because then the next meeting is December 9th, where we'd have to fully vote on the entire report. Does that sound reasonable? Make sense to everybody? Is everybody clear on the timeline? And Mario, would you be able to send that timeline out after this meeting? Okay, great. Okay, so that is essentially the timeline. So anything ideally, so I know some of the topics that Shauna brought up will be brought to some of those subcommittees between now and October. So they may or may not make it into the report, depending on where those subcommittees land on those things. But ideally, we're voting on other additional recommendations at the October meeting. Okay. Questions, comments, concerns? Okay. Okay, so then moving on just to, I already mentioned the October meeting. It's October 14th. It's at 1 p.m. here at the Legislative Office Building. And with that, I'll move to adjournment. Can I get a motion to adjourn? Great. Great. All in favor? Great. All right. Have a great rest of your summer. Bye, everybody.